So much for your patience, first and foremost. It's, of course, Patrick had patience with us, so of course we have patience with you as well, and I'm sure President Davis feels the same way. And so before we get started, we are running behind. I want to, before we bring on our guest, ladies and gentlemen, candidate Patrick Sweeney, running for Court of Common Pleas, please make sure to share, subscribe, send your questions, put your questions in the chat. We will take out some time and ask if he can answer them. But before we start with our guest, we're going to ask President Davis to just introduce himself and let you all know that there is the chapter here in Pittsburgh of the NAACP.
Hello, everybody. Hello, Mr. Sweeney. It's good to see you again. I know you are a lifelong committee man, and I am excited to see you in this race for Court of Common Pleas. I know Ms. Terri will take good care of you and her questions during this time, especially during the Civic Engagement Series. We appreciate your time and willingness not only to answer these questions, but it will allow voters here in Allegheny County, and especially here in the city of Pittsburgh, to know where you stand, how you want to reform the court, and what awesome powers, if you're so lucky to be chosen to sit on the court, what you will do with those awesome responsibilities. So, again, thank you for coming, and I'm gonna hop off and let you guys get to it.
Okay, thank you, Mr. President. We'll talk to you later. Okay, so thank you, my friend. I am so sorry. From the last time, our calendar, our tech, it was just crazy. So I want to thank you for that.
No problem at all.
Yes, and I'm so happy that we finally got to, get you on our community educational civic series. Pick your brain and see, just as the president said, if you're lucky enough, what can we expect, out of your leadership on the bench? So before we get started, is there anything any questions that you have before I ask my first question?
No questions for you. Just I know I'm a little bit late. I was stuck down at the county jail talking to a couple of my clients, and they were fortunate enough to let me leave, and I rushed over here as soon as I could. So thank you for having me, and thank you for being patient with me. So.
Well, we thank you so much for that. Okay, so let's just get started. In the very first question, simple question, Patrick, is of course I know you, been knowing you for years, but for someone who do not know you, tell us, who are you?
Okay, well, my name is Patrick Sweeney. I'm originally from Brighton Heights, and my dad got a job at IUP, so the family moved up to Indiana, Pennsylvania. That's where I went to high school. Since high school, I've been back in Pittsburgh. I went to Pitt for my undergraduate years and my college and my law school years. And aside from a brief period of time, just after I was sworn into the bar, I was working for an attorney up in Brookville, PA, which is one county north of Indiana, where Punxsutawney is, Jefferson County. I describe it as I was the third lawyer in a two-person law practice, which didn't have much of a future, but it was a great learning experience for me. Going around all those little county courthouses. But I've been back in Pittsburgh ever since. I took a job with the Allegheny County Public Defender's Office, which was not necessarily what I planned when I was in law school. But once I started, it just clicked with me personality-wise and with the work and with the mission. And, I love my work. And that's the reason why I've stayed as long as I have. I've been there 25 years now. I'm a career public defender and have been trying cases, not only in the adult criminal division, which is where most of my experience is, but I've also had assignments in juvenile court with juvenile delinquency work, handling mental health commitment hearings, as well as the appeals, which are argued in orphans court, and even handling civil contempts, like contempt of court. PFA violations used to be argued in civil division as well. But in my years in adult court, I've tried everything from shoplifting to homicide. I've tried dozens of jury trials, hundreds of non-jury trials. I've represented thousands of clients over the years from every part of Allegheny County. The one thing they have in common is that they can't afford their own lawyer. If you watch court shows and cop shows, you know, the Miranda warnings, you know, if you can't afford an attorney, one will be appointed. In criminal division, that's us. That's the public defender's office. And that's our mission, is to make sure that those folks are treated fairly, not run roughshod over simply because they can't afford to hire their own attorney. So.
Yeah. Thank you so much for that. And I don't know if you see me jotting down, because there's several things I want to comment on your answer. And first and foremost, thank you so much for that, Patrick. And first I want to make sure that our listeners, because this is an educational civic series, understand the difference between, because I had this conversation between the magistrate and between a court of common pleas. Who sets the bail?
The bail is initially set by a magisterial district judge, either at night court or in front of their own court. Those are what we call the minor judiciary. They are, elected in smaller districts. There's dozens of them actually in Allegheny County. It might be 3 or 4 wards of the city, maybe even 1 ward of the city of Pittsburgh. It might be 2 or 3 or 4 townships out in the suburbs lumped together. And those folks are elected to 6-year terms, and then they run for re-election in a normal election where multiple candidates can run. In the Court of Common Pleas is one step up, so it's the trial level, and those are elected countywide. And in some instances, in some parts of the state of Pennsylvania, there are multiple counties, like maybe 2 counties or 3 counties in a judicial district. Allegheny County is not only big enough to be its own, but it has many, close to 40, I think, permanent seats on the bench, county common pleas level. There are 4 divisions in Allegheny County, and again, it's rural counties. You might have 1 judge or 2 judges, and they hear everything. In Allegheny County, because of the volume, because of our population, our caseload, it's divided into 4 divisions. Adult criminal, which is where most of my cases are heard. That's what you see on crime shows. That's juries as well. And to be quite honest, the overwhelming majority of our cases that go to trial are non-jury trials, where the judge makes the decision as to whether the burden of proof has been met. But jury trials are heard, of course, in criminal court. Civil division are your lawsuits, landlord-tenant actions that are appealed, slip and falls, asbestos cases, neighbors suing each other, medical malpractice, that kind of stuff all goes to civil court. Orphans court handles, I mentioned earlier, mental health court commitment appeals, but it also deals with guardianship issues. It deals with will contests like estates and those kind of things. And then family division, which is a growing division that has not only the juvenile delinquency issues where public defenders come into play, but also dependency issues, CYF issues where there's the counties may be trying to take kids away. There are child custody cases. There are divorce cases. That's all handled in family division. And I've been fortunate to have practiced in all 4 of those divisions. But that's the common pleas court. That's the trial court level. And those are elected. We are elected, if I were to win, would be to a 10-year term. And then at the end of that 10-year term, the judge, if they so choose, can seek retention. And that is simply a yes or no, should judge so-and-so be retained. And then if the answer is yes by the voters, then they get another 10 years. And that's not an actual election where they have multiple candidates running.
Several things I want to thank you so much, because the retention, me personally, I just learned that maybe in the last 8 years, maybe, I just literally learned about the retention vote with the common plea judges. I also want to make sure that we touch on what you were saying when I asked the question, the original question of who sets the bail, because 2 things. One, this is why I love these educational civic series, is because 1, I was wrong. I had told someone, so that's why I answered, because I was wrong. I said it was not the magistrate. And 2, I was wrong again about the daylight savings time. I thought a mayor had the power to do that, and it is not true. It's transportation.
So personally, we get rid of it, but
exactly. I was like, why is this? But yes, so I just want to make sure that I threw that. And I'm so glad that you touched on every single office, every single seat, because again, I learned something within the last several less than a decade ago. So I want to thank you so much for that. But I want to come back onto the jury comment on. I want to go a little further on your comment about jury trial.
Sure.
So right now, if anyone say, hey, I don't want to take this plea. And of course, one person may have the power, or one person may not. Let me ask you: do you have the power? That the way that our system is set up now is, if I do not take the plea of 5 years, and I get found guilty from a jury, I may wind up getting a sentence of 25 years. Explain that to us.
Well, yeah. So there are, if you're charged with a crime, you have a right to a trial, and that could be a jury trial or a non-jury trial. You could also enter a plea of guilty. You could also enter a plea of no contest, or nolo contendere in Latin, where you're basically saying that the charges against you, if they were to be believed, would be sufficient to convict. The evidence that the Commonwealth would the effect is the same. It's still a guilt. It's still a guilty verdict. It's just you're not making an admission under oath that you committed a crime. And in certain circumstances, if you're potentially looking at civil liability, you may want to avoid making an admission on the record that could be used against you in a subsequent civil trial where someone's trying to get money out of you. So that might be why no contest pleas come into. It also could be just pride and somebody just recognizing that there's a really good offer on the table and they don't want to risk rolling the dice and losing. And people enter guilty pleas under those circumstances as well. So sometimes when people are looking at very serious charges, and they're part of the calculation that we make, and I've had this conversation with clients many, many times over the years, is, we have the bird in the hand here. We have this offer that's on the table. If you plead to such and such charges, this is what the sentence recommendation will be. Very likely the judge will accept that, although they don't have to. But on the other hand, if you risk going to trial, the original charges will be back on you, and taking a plea is what we consider a mitigating factor. If you acknowledge your guilt and you save the victim of the trauma of testifying, and you save the cost of a trial, that's a reason for the judge to go lower in the sentencing guidelines and cut you a break when it comes to sentencing. Whereas if you assert your innocence and you are found guilty, either by a judge or a jury, that mitigating factor is no longer there. There could be other mitigating factors, and they may be so significant that they outweigh any aggravating factors when a judge is weighing what to sentence the defendant to. But generally speaking, what I tell folks is, if you go to trial and lose, you're looking at what we call the standard range of the guidelines in terms of a minimum sentence. And, you're given a prison sentence or a jail sentence in Pennsylvania, you get a minimum and maximum date. So you can get, you probably heard a lot of 11.5 to 23 months. If the second date, the maximum is 2 years or more, that's a state prison sentence. If it's less than 2 years, like 23 months, that's a county jail sentence, which means you serve it in the county. It's easier for your family to see you, but also, most importantly, the judge who presided over the plea has control over when you're paroled. Whereas if it's a state sentence, the parole board has control over that, and they may be a lot less lenient. So those are some of the factors that come into play when you're deciding whether or not to have a trial, or whether to accept a plea that's been offered to you. And you talk over your case with your lawyer, and you make a decision based on the evidence that you think is going to come in, whether it's a safe risk or not. There are judges who apply what we call a trial tax, in terms of if you go to trial, you're going to get a worse sentence. And Judge Nauhaus used to jokingly refer to the mitigated range, the standard range, the aggravated range of the guidelines, and then there's the aggravation range of the guidelines, where if it's something that very obviously shouldn't have gone to trial and does, you might get a little extra. I think usually what most judges, though, you're looking at the standard range if you lose at trial. Now, if it's a really bad case, like a child rape or a shooting or a murder, or even like a manslaughter, you might be looking at the aggravated range of the sentencing guidelines. But that's usually when a judge really wants to knock your head off and is stacking consecutive sentences one after the other. And those are for the most serious cases.
And so my question is, and you may not be able to answer it if you're fortunate enough to become the next judge of the Court of Common Pleas, because 99% of the time when someone, specifically if someone of color, take a plea, it's because we're too poor to pay for an attorney to take it to trial. So when someone does not have enough money to pay for an attorney, and so they have to take it and they take it to trial. But the way that the system is that predominantly people that does not have any income does not have the fair shake of saying, hey, I have to take this plea. I have no other choice but to take this plea. So my question is, being as though that choice is now in the judge's hand, that the judge knows that your plea was just 5 years. Mm-hmm. This jury just found you guilty, but now I have the power to sentence you to 25 years.
Yeah.
And let's take it a little even further. We all know who has money and who don't have money. Mm-hmm. You know, we all know that is a fact, that people that cannot afford, we have to take a plea. Is there something that you know, a judge of your caliber, or someone sitting in the Court of Common Pleas, how, if you would look at something like that? And again, is that something that you can answer?
Well, I mean, if getting back to what I refer to as the trial tax, that is not something that I would apply as a judge if I were sitting in criminal court. I think people who have the right to assert their innocence, they may have a very good potential suppression motion that, even if I were to ended up denying it, I don't think you should be penalized for making an argument in a pretrial motion, or be penalized simply for asserting your right to have a trial, whether that be a jury trial or a non-jury trial. So I hope I would eventually develop a reputation as somebody that would not punish someone simply for asserting their right to have a trial. You do get into that area where there's a mitigating factor that's no longer there when you're no longer admitting it. But with respect to, I do know that there's a perception out there that people feel like I don't have the money to go to trial.
Listen, you don't have a choice.
I will defend myself and my colleagues in our reputation as excellent lawyers. We win a lot. We win quite often over this DA's office when we choose to go to trial. Now, you pick your battles and you pick the cases that you think you can win.
Right.
But we have a budget for experts. Obviously, we wish it were greater. We do have expert witnesses to testify in narcotics cases and accident reconstruction and even false identifications and these kinds of things. So we do go to battle often, and we win a lot. And I would honestly, if I were to be in a position to be a defendant, I would rather have most of my colleagues in the public defender's office representing me than most of the private defense bar. None are watching this and offended by that. But a lot of the private defense bar, their business model depends on people having a poor opinion of the public defender's office. And so, there's certain comments that are made about how, well, the PD won't do this, but we'll do this other thing. I think the decision to take a case to trial or not should not be based on how much money you have. Mm-hmm. But and if that is the perception, I think it's an incorrect perception, because the public defender's office and conflict counsel, we provide excellent representation of the people that we represent in court. And I would put that up against the legal work and work product of the private defense bar any day. So
thank you so much for that. Two things that I'm so glad that you of your answer. I really respect your answer, because I read something that you had said, and you had said this before you, I don't know how long you were considering running for the Court of Common Pleas, but this was done, this statement was done several years ago. So this wasn't something that you said. And I want our men and women, our audience to understand that this, what I'm ready to read that you said, and that's why the reason that I asked you that question is because this isn't something that you are saying on the campaign trail. You literally said, you know, that a judge cannot legislate from the bench. Cases brought before a court should be heard by a fair and impartial jurist who takes into account all parties. And I, you know, when I read that, and this, as I said, this wasn't something that was just stated. And so I respected that. And that's why I wanted to make sure that I asked you that question to make sure that, you know, other people is hearing and seeing what I heard and seeing what I saw. So I want to thank you for that. And I also want to comment on when you said, you know, right now, public defenders are winning a lot of cases. And again, I have to give credit where credit is due. That is absolutely true. Within the last 9, 10, maybe 12 years, there was a shakeup there. There was people moving around, people moving out, people moving in, and literally the wins can be saw. You know, we're seen. So I want to make sure that I commented on that because that is you did speak truth to that as well. So thank you for that.
Well, yeah, I mean, and look, we have high caseloads. I mean, that's still true. As much as it's improved dramatically in recent years, it could get better. You know, fewer cases per lawyer enables us as public defenders to devote more time and more energy and resources to each individual case. When I first started, it was on the heels of a lawsuit that had been filed because the public defender's office budget was slashed by close to 40%. They laid off like a third of the attorneys. I was the first class of hires that were not hired back people who had been fired. I was a new hire. Now there were 4 of us that came in. We now have part of that settlement of the lawsuit was to increase staffing levels. So we have much higher staffing levels in terms of attorneys, more supervisors now. We have social workers now that work on our office. We have more investigators. The pay has increased dramatically, particularly at the starting salary. We just had a big win in our contract in December, which I played a lead, although, you know, it was a team effort, but I was a big part of that effort as well as one of the union reps. But yeah, it's better now than it's been in a very long time. It could be better still, certainly. And I think we always have to be vigilant to make sure that indigent defense, whether it's public defenders, conflict counsel, or court-appointed attorneys, have the resources necessary to provide an effective defense.
Yeah. Wow. Thank you. Thank you so much for that. Yeah. Thank you. Thank you so much. My next question is, and I only have a couple more, and I'm going to look in the chat and see if you have any questions. But my next question is, can you, a twofer, this is a twofer. What can be done if you're blessed enough, fortunate enough to become the next judge in Court of Common Pleas? What can be done at that level to stop recidivism, or to put a dent in recidivism, and or can you see your office hiring someone with a colorful background?
Well, in terms of, listen, there's a guy that sits outside of my office who I talk with every day, who was he wasn't pardoned, but he had his sentence commuted. He was convicted of murder about 40 years ago. He was an attorney. He's now working as a paralegal in our office, and he does the expungement petitions. He's an older guy now, but he spent decades in prison and eventually showed the pardons board enough evidence that his conviction was probably inappropriate and shouldn't have occurred, that they actually commuted his sentence and let him out. Our office has hired people that have had prior run-ins, not only as attorneys, now granted, you also have to be sworn into the bar too. There's a character and fitness test that comes with that, but also we have people who work in our office who have been through the system, in support staff positions as well. What can a judge do? I think what we have to focus on is alternative solutions to recidivism. The overwhelming majority of cases that I handle, that our court criminal division handles, are issues with drugs and alcohol. And very often the reason why somebody gets into drug and alcohol abuse is because they may have had an untreated mental health disorder that stems back to their childhood, and the lack of, proper insurance and the lack of care and the lack of diagnosing that has caused this to snowball as they've entered their adult years. And also people that maybe they were diagnosed appropriately and they're just not getting the care that they need. People that have mental illnesses, when they act out, we don't have the mental health facilities that we used to have. We used to have 19 state hospitals. Now we have 2. The only one in the western part of the state is Torrance. When I started, Mayview was still open, but it was on the way to being closed. There just aren't facilities like that anymore. It was supposed to be replaced with community care, and that funding has dried up. And so I think what we see, and mental health court has finally, I think, opened the door to allowing people to get into the mental health court programs without necessarily requiring a conviction first, or at least allowing a delay in the implementation of a verdict or disposition, so that if you do complete the program effectively, you might get an expungement, or you might get a reduction of the charges or withdrawal of the charges. We need to have more of that, not less of that. Drug court, mental health court, veterans court were all post-conviction courts. You had to be convicted of something to have the resources applied to you. And I think that's completely backward. I think we need to apply the resources to people earlier on in their career, if you want to call it that, earlier on in their involvement in the criminal justice system. So we don't wait until they are so bad they're almost, beyond redemption. We want to get people into treatment earlier and more often, so that they have the tools to deal with their addiction. And that will, I think, have a huge impact on recidivism, because it's mostly that kind of thing. It's not simply just sociopaths that think the world owes them. It's drugs and alcohol and mental health abuse, mental health disorders that are not treated properly. And I think all judges, whether they're presiding over those treatment courts or whether they are fashioning sentences in their own courtrooms with the assistance of some agencies, need to take that into account and enable. There has to be a system where we can sweeten the pot a little bit. I think judges have a big role in that.
Yeah, wow. One thing I want to just make sure that I say real quick that I want to elaborate on is that even having you acknowledge that three top, lack of insurance, mental health, and drug abuse, having someone, on the seat of a court of common pleas with already having that awareness is extremely important. So I want to make sure that our viewers heard exactly what you had stated, that, that you already have this, thought process of our issues already. So I want to make sure that I respect you on that. And I thank you for that answer.
Thank you.
A couple more questions. This next one, Pat, is why you? Why should somebody vote for you?
Why me? I think, I talk about this on the trail. Pretty much every person that has ever been elected to a judicial position has campaigned on the idea that they would treat everyone fairly and that they would listen to everyone. And that's certainly part of my pitch as well. I quote Proverbs, the public defenders are supposed to give voice to the voiceless and bring justice to the dispossessed. And that's what judges are supposed to do. In fact, that passage is all about how one is supposed to be a judge. Some judges lose sight of that. And I think the system can grind people down a little bit, but I think when you've done what I've done for the last 25 years and been standing shoulder to shoulder to the people that are most likely to be ignored and dismissed by the criminal justice system, the poor, people in minority communities, people with mental health disorders, people from marginalized communities are my entire clientele. And while this is a very rewarding job and it can be fun a lot of the times, it's also very frustrating because I see decisions being made by judges when I'm in court advocating for someone and it's going unheard. So, the difference between an advocate and the judge is the decision maker, and the judge is the one that makes the ultimate call. And I think I'm more likely than most to remember what it's like to be in that position, standing next to the person from a marginalized community. I'm not a member of a marginalized community, but
Right,
I've been
right.
advocating on their behalf, and I'll probably be more likely to remember what it's like to be in that position, and I think take that into account, just because of what I've been doing for the last 25 years.
Yeah, yeah. And thank you for that, because literally you answered my next question. I literally was going to say, what made you say, you know what, I'm jumping in. I'm going to get off the sideline. I'm going to stop saying this needs to be done, and I'm just going to get and get into the ring. And so, I mean, but you answered my question. For the last 25 years, your clients, the poor, the people that look like me, you have sat back and you have watched the mistrust and the unjust. And
Yeah.
so, and like you said, and you have been doing this for the last 25 years. So that is your why. So I appreciate that. My next question, we're ready to wrap it up, is if someone wanted to get in touch with you, if someone wanted to say, I have different questions I want to ask, or they may even want to donate. They may even want to volunteer. How can someone get in touch with you or someone on your campaign?
Well, I have a website, which is real easy to remember, patricksweeneyforjudge.com. It's Patrick Sweeney for Judge, all one word, and it's SWEENEY. The email that is my campaign email is patricksweeneyforjudge@gmail.com. And again, that's Patrick Sweeney for Judge, all one word. And we'd be happy to address any concerns. And in the website, there is a link in there that if one wanted to donate. I'm personally not allowed to ask for money, but if somebody logs on there and that's what they're looking to do, we will certainly accommodate them. So.
Right. So you know what? I cannot thank you enough for coming on. I know your day you was running from the jail and then running to your clients, and so I want to thank you so much for taking the time out of your day to join us on our community educational civic series. Before we wrap this up, is there anything else that you would like to say before we end this for tonight?
Well, I did notice there was a question that popped up here asking what my position on possible reopening of Schumann or a similar authority. I am in favor of having some facility. It needs to obviously be run more appropriately than Schumann was. The problems of kids being harmed when they're in there and allowing drugs in there and the violence that was going on occasion, that needs to be addressed. It needs to be run much better than it was. I am also very much in favor on that being a public facility and not a private facility. I think we saw up in Luzerne County and in other places, if you create any kind of a profit motive for locking people up, that is a recipe for disaster, particularly when you're dealing with kids. And that's what the Schumann's mission is, to help straighten these kids out if we can. We have really difficult decisions to be made. 13-year-olds being charged with homicide. Does a 13-year-old belong in a county jail? Of course not. But there really isn't anywhere to put them within Allegheny County, and we need to have somewhere to try and work with these kids. And somewhat different than what Schumann was, but a similar mission. Yes, there definitely needs to be a facility in Allegheny County, and I hope it's a public one.
Yeah, well, you answered my next question with the privatized or public. And so thank you so much, Maggie, Miss Johnson, for that question. I don't see any more questions. And so, Patrick Sweeney, candidate running for a judge, for Court of Common Pleas here in Allegheny County. Before we go, is there anything else that you would like to say?
Just alluding to what I said earlier, I think the people ask what's the biggest crisis facing our society and our courts, and I think it's got to be the way we address mental health disorders and the drug and alcohol abuse that goes hand in hand with it. And we have a lot of wind in our sails now, I think, electorally. It used to be that was to treat people more leniently, if you will, or be more compassionate and to recognize that there's maybe a health issue as opposed to simply not being afraid of punishment being the source of someone's recidivism. Voters are actually electing people who I believe are on the right side of those issues now. And judges are not going to be afraid to take those positions and take those stances. And so I'm excited for that. And I'm excited, I hope, to be a candidate that would appeal in terms of my candidacy and my background to folks that are embracing those issues of reform, because that's kind of what I want to bring to the table with me if I'm fortunate enough to be elected. So.
Well, ladies and gentlemen, there you have it. Thank you so much, candidate Patrick Sweeney, running for judge of the Court of Common Pleas here in Allegheny County. Would you like to share your website, your information again before we jump off and call it the night?
Yes, it's patricksweeneyforjudge.com is the website, and patricksweeneyforjudge at gmail.com is the email address.
And there you have it. Please reach out if you have a question that we did not discuss, if you want to volunteer, if you want to even donate, or even just to read up more on the candidate Patrick Sweeney running for judge in the Court of Common Pleas in Allegheny County. Good night, ladies and gentlemen.